Welcome back to the channel. I'm so glad you're here. There is so much to talk about, and in this video just talking briefly about some of the documents that have been released unsealed, which were originally filed under seal, meaning nobody could see them. Many of these documents include motions in limine, which is effectively an application to have some evidence excluded from the eyes of the jury so that the jury cannot see that evidence. And there is some very interesting arguments within these documents themselves. This one document that I'm looking at today has a number of different arguments within it, with Amber Heard's lawyers arguing essentially to blame lots of other people for various different things, trying to include evidence that perhaps shouldn't be included, exclude evidence that perhaps should well have been included, blaming social media, blaming Johnny Depp's conduct towards other people, blaming Waldman, blaming the police officers, and so on and so forth. Very interestingly, as the title and the thumbnail of this video suggests, blaming the UK judgment and trying to bring that in as part of evidence to the Virginia trial, which, as we've said many times, would have been prejudicial, would have no doubt swayed the jury, because if the jury had have heard in full about the UK trial and the verdict and so on, that would have been prejudicial, meaning that they would possibly, quite possibly, have just come to a decision on that trial in Virginia based on the UK verdict. Now, obviously, that shouldn't be the case. Lots of people have been arguing, even some professionals have been arguing, that this has all been argued out before in the UK trial and therefore should not have been re-argued in Virginia. That argument was made in the Virginia trial, leading up to the Virginia trial, and was denied. So obviously, the trial went ahead, and the UK verdict, as you'll see in a moment, was ultimately decided that it should not be brought up to the jury, even though some of these documents make it very interesting reading as to these arguments, which were sealed beforehand, where Amber's lawyers were effectively arguing that this should be shown to the jury, Johnny Depp's lawyers were arguing that this should not be shown to the jury, so on and so forth. These documents include transcripts. I'm not going to read through all of those in this video today. They may well be better placed for another video, but there is a lot of material with a lot of interesting reading, and so I'm going to go through a little bit of that in this video now. So moving to that document now, you'll see the way that I have set out this document. I have put just a few of the bookmarks here, which we usually do with PDFs. And jumping here, you can see this actually jumps much further on in the document. This is to the transcripts. But you can see here these were originally filed under seal, under an amended protective order. So they obviously did not come into the eyes of the jury or indeed anybody beforehand. These were lots of arguments, motions in limine. There are several different motions within here about various different bits of evidence, some of which I'm going to talk about here, which I thought you might find interesting, because I do know that there's still a lot of interest in this case, because it is one of the first times really that this kind of case has come to real public scrutiny as well as interest. So moving first of all to this court ruling here, this is talking about the litigation in the United Kingdom. So I've highlighted various bits here, which I found to be very interesting. But first of all, just looking at what this argument was. Introduction and summary of relevant facts and issues. So remember, this was all filed under seal. So these were, if you like, quiet arguments between lawyers and the court that the jury would not have been aware of. So here summarized: as the court is aware, Mr. Depp previously engaged in litigation in the United Kingdom against the tabloid The Sun. The tabloid, for those that are not aware, is essentially just a newspaper that engages in stories, gossip, news, popular news, and all of that sort of stuff. And so which involved the allegations of abuse between Mr. Depp and Miss Heard. The particular case resulted in the UK judgment in favour of The Sun. As the court is also aware, as in the Virginia court, as the court is also aware, the UK judgment was rendered in a different court. Now, this is a double-edged sword, as I've been saying all along. Rendered in a different court, in a different country, in an action between different parties with different rules of discovery. Discovery, for those in England and Wales, will understand to be disclosure. And for those that don't understand discovery or disclosure, it is essentially, I actually think discovery and disclosure are words that very well describe what goes on here. So each party have a duty of disclosure in England and Wales, and it's a process of discovery in the United States whereby parties have to show what documents they have, which might undermine their own case or assist the other. And indeed, those documents that they say support their own case. So essentially, each party must tell the other what documents they have that support or undermine their own case. So different rules of discovery between different parties in a different court in a different jurisdiction. And this is very important here, different rules of evidence. So this is starkly drawing the difference between the two trials. Now, this was, of course, Johnny Depp's lawyers arguing that this decision should not be brought before the jury because it would be prejudicial. So, on this basis, this goes on, among others, this court overruled Ms. Heard's supplemental plea in bar by letter and opinion on 17th of August, determining that the UK judgment had no preclusive effect here. Preclusive meaning it should not sort of prevent anything from happening in Virginia. In other words, it should continue. In so ruling, the court found that this supplemental plea in bar was misguided. That's a polite way of saying it was wrong and shouldn't have been made. And only thinly supported by pre-existing law, the procedural substantive laws regarding libel, etc. So, that to enforce the UK defamation judgment in this case would go against public policy. So, in other words, with all of this, if they were to enforce the UK defamation judgment, bearing in mind it was a different court, different country, and so on, in the against the case in Virginia, it would be against public policy. Public policy meaning that the case in Virginia should have gone forward. In short, the UK judgment has no weight in this action. Now, I'm going to pause just for a moment there and remind you that Elaine had gone on essentially a press offensive to talk about the UK trial. And indeed, in the jury comments and in cross-examination, there were various references to the UK trial, the UK verdict, and so on. And just the arguments here are quite starkly that the UK judgment had no weight in this action. It represents findings made without personal knowledge of the underlying facts based on evidence that would not have been admissible in this action in the context of different legal issues. Different legal issues being because obviously it was with the Sun newspaper and not Amber Heard, albeit the underlying facts of the case were the same, the legal issues were different. But that's not to say the two decisions are compatible, which is an entirely separate argument. So on that note, just to pause very briefly, if you haven't yet signed the petition to have the English legal system take another look at the decision made in the English courts, please go and sign that now. It is linked in the description of every single video. I have not forgotten about it. It hasn't gone away. It needs more signatures. It needs more attention. So I would urge you, please go and sign that if you haven't already. I know many of you have, and I thank you for that. Moving back to this document. So, as such, it is irrelevant, hearsay, and above all else, would be unfairly prejudicial to allow Ms. Heard to present a finding by a UK court that her claim that Mr. Depp was a WB was substantially true to a jury. So this is really the crux of the argument. It would be unfairly prejudicial. and without being condescending to anybody, unfairly prejudicial, effectively meaning somebody with no knowledge of this whatsoever could turn up to sit on the jury. They could be told this information and then immediately make a decision based on that information. But for lots of reasons, they should not make that decision based on this information, because it's, as I've just said, it's different jurisdiction, different law, different parties, different legal issues, so on and so forth. So they should not link those two together. They should not make that decision, but they probably would. If you think about this logically, if a party with no knowledge, if they hadn't even heard of Johnny Depp, they hadn't even heard of Amber Heard, no pun intended, if they hadn't heard of either of them, and they came in to sit down and listen to all of this evidence, and the evidence included the judgment in the UK trial, they would fairly certainly be swayed, not necessarily entirely, but they would fairly certainly be swayed by that decision in the UK courts. So if that were the case, that would be prejudicial, that would be wrong, that shouldn't be allowed, that shouldn't happen. That's the point of this argument here. So this was all of this argument here. And it goes on, unsworn hearsay, remember, anything that is not said in oral evidence. So unless it's a person coming to court, giving it on oath and being cross-examined and tested, the UK judgment, this is one of the arguments, the UK judgment ultimately constituted unsworn hearsay. And if offered in evidence in this action, the contents of the UK judgment would be hearsay, not within any exception. An exception is, obviously, with hearsay, there are certain exceptions that allow hearsay into evidence. So even though something is hearsay, it can be allowed into evidence. But there was not any exception here that would allow the UK judgment in as hearsay. So again, this was an argument. Essentially, this argument here by JD's lawyers says that a statement of opinion of a single court in a foreign jurisdiction. In fact, the UK judgment contains multiple levels of hearsay, which it did. I've discussed many of them, as it recites out-of-court statements of witnesses that testified or submitted witness statements in the UK action, often in violation of Virginia evidentiary rules. So what this means is witnesses that had given evidence by way of hearsay in the UK trial would have violated evidentiary rules of evidence in Virginia. And so this is hearsay upon hearsay, which is breaking rules that would not ordinarily be allowed in the Virginia trial. Concerning hearsay statements relayed to them by others, Virginia law is clear, hearsay is not admissible. And in fact, I've said many times, hearsay by default is not admissible unless there is a reason or a rule or a probative value. And as we've said many times, the question is often raised, certainly in England and Wales, is it more prejudicial than probative? In other words, is it more likely to cause an unfair bias in someone's mind that overweighs or overbears the evidential value of the information? And so that is often a question. If offered for the truth of its contents, and that of course goes to the definition of hearsay, because hearsay is something that goes towards proving the truth of the matter stated, then the UK judgment, the multiple levels of hearsay therein, are inadmissible hearsay that doesn't fall within any exception. Pure and simple. So absolutely, this argument here is a fairly clear-cut, slam-dunk argument that this UK judgment should not have been in evidence in any way whatsoever within the Virginia trial. And here we go on, as I just said, the probative value of the UK judgment and so on and so forth, substantially outweighed by the danger of unfair prejudice. This is what I'm talking about here. Is it more prejudicial than it is probative? And this argument is absolutely yes, it is. It was far more prejudicial than it was probative. And that goes back to the argument that I just said, that absolutely it would have been more likely to have been prejudicial than the probative value. It's more likely to make any jury member to think that one way for their decision than listen to the evidence, even if they hadn't heard of any party before. But moving on, that was one interesting argument, to read those arguments that were made, but also looking here, going on essentially trying to blame the police officers. And again, this was arguments against those arguments. So reading out this is a very interesting portion of these documents. On May 21 of 2016, two separate pairs of police officers responded to a call at certain penthouses in LA where they maintained residence following an episode of purported violence, during which she contends that she sustained injuries to her face and so on, and he threw the phone. This was the phone incident. He denies any such things, and the officers in question saw no injuries, importantly, and saw no property damage and left. And as such, they were witnesses that saw a lack of any injuries and property damage. And that's the essence of the testimony. They are not, of course, parties to the action, and no claim has been asserted based on any allegation of misconduct by the LAPD. In other words, they did their jobs properly and they saw no injuries. They were witnesses and they saw no injuries. And this is where it gets interesting. Ms. Heard, unfortunately, appears determined to engage in an attack on these officers, arguing that they somehow failed to follow proper police procedures. She'd retained an expert on that topic and deposed the corporate designee of the LAPD on 4 separate occasions on multiple topics, and multiple corporate designees. And given the language here is indicative of the mindset of the lawyers writing it. Given her scorched earth approach on this topic, it is readily apparent that Ms. Heard intends to spend time at trial arguing to the jury that the police officers who arrived at the residence failed to follow procedures. And that, of course, we saw play out. So that alone is an interesting argument. Then they turn and remember that this document is Johnny Depp's arguments against those of Amber's lawyers, which the arguments become clear. But just so that you're clear that I'm not reading out arguments from Amber's lawyers, see, this is the arguments against. I thought it's self-explanatory to read out these arguments against, which explains what their arguments were. So then it turns to arguments against Mr. Waldman. So based on Ms. Heard's conduct of this action to date, it's anticipated that she will attempt to distract and confuse the jury with irrelevant and salacious allegations against Mr. Waldman in an effort to taint Mr. Depp with Mr. Waldman's supposed misdeeds. For instance, she inaccurately accused Mr. Waldman of pressurizing witnesses to give testimony, and based on her efforts to explore the issue at deposition, can also be expected to attempt to inform the jury in this case as a result of technical violations and so on and so forth. So again, on that occasion, trying to attack Mr. Waldman, and essentially based on those supposed actions, taint Mr. Depp with those. Then moving on, blaming supposed behavior towards other people by Johnny Depp. So, as the court well knows, this action revolves around allegations by Miss Heard that Mr. Depp physically abused her. Allegations he denies and intends to disprove at trial, which, of course, that's what happened. It's anticipated that Miss Heard will seek to improperly influence the jury by attempting to introduce evidence of alleged violence in the past towards other men as well as unrelated arrests. So again, yet another argument trying essentially, in my view, a smear campaign of many other things that she says that he did, and again use those to attack his character. Now I'm just pausing for a moment to talk about character. Character is something where if you attack someone's character, then ideally and ordinarily you need the permission of the court to do so, but then also if you do that, it's normally fair game in the reverse. So particularly if you do that without the court's permission, if a witness just blurts out something of an attack on character, then the reverse is normally true. The reverse attack on character can then just happen, usually without further order of the court, because it's taken to be fair game. So ordinarily you don't do that. It's not usually playing fair, it's not proper, and it shouldn't be done. So moving back to the document once more, I just thought that was worth bearing in mind. So then it goes on arguments about the arrest record and various other things. And again, this argument here of probative value outweighed by unfair prejudice and likelihood of misleading the jury. You'll remember that I've talked in a number of videos now about whether or not the jury have been misled. And this was certainly a concern of Johnny Depp's lawyers, according to these documents, all the way through leading up to the trial, not even at the trial by that point. Moving to another one, I've literally, you can see I've got a few of these things to talk to you about so that these videos are not far too long. But then moving to social media, this one again is a recurring theme both before, as it happens, and after the trial. So again, the language of the lawyers here really gives you an insight into the mind of the lawyer drafting these arguments and makes very interesting and compelling reading, particularly in light of the decision in the trial and the behavior afterwards, the arguments afterwards, and as it happens, the apparent and the ostensible blaming of social media. Among the more preposterous claims asserted by Ms. Heard in her counterclaim was the wild theory that she was the victim of a campaign of negative social media attention supposedly orchestrated by Mr. Depp to smear her through an army of bots posting negatively about her. The conspiracy was reflected in Ms. Heard's third claim in her counterclaim for alleged violation of the Virginia Computer Crimes Act. Now, let's just be clear that if people are directly attacking somebody on social media, that's obviously not acceptable. It shouldn't happen, and it should be reported and dealt with accordingly. Where it is with proper comment, proper argument, and discussion and so on, that's obviously different. But if people were doing that, that should be dealt with. But that said, it is suggested in this argument is that it was a conspiracy theory. It was a wild theory that she was the victim of such a hate campaign. Specifically, Ms. Heard alleged in her counterclaim that Mr. Depp initiated, coordinated, overseen, and or supported amplified two Change.org petitions to tarnish job opportunities and created, coordinated, controlled, manipulated social media accounts created specifically for the purpose of targeting Ms. Heard. Also alleged that the campaign had some sort of Russian connection. This, in my humble view, is really clutching at straws. Apparently because Mr. Depp's former counsel, obviously Mr. Adam Waldman, is known to have represented a high-profile Russian businessman. Well, so what? So have I. I mean, I've been in cases before now that involved people overseas and including of Russian origin. So that doesn't mean then that every time, I'm talking about myself now, obviously, that doesn't mean then that anyone that I'm representing that I'm going to have some kind of Russian connection within social media to disrupt and destroy someone's reputation on social media. I think it's really far-fetched. And quite disparaging and defamatory in and of itself, in my view. This argument goes on. Miss Heard's attempt to state such a claim was perhaps based on the premise that the jury will be predisposed to be hostile to Mr. Waldman and, by extension, Mr. Depp, based on headlines in recent years, from Russia's recent invasion of Ukraine and so on and so forth. So, quite clearly, the tactic, if you like, which is argued in this document, is that there was a concern that she was going to argue that because of a connection to a Russian businessman, that the jury are likely to be hostile towards him if they believed that this Russian connection meant that there was some kind of attack by social media supported by Russians, emphasized with the recent Ukraine activity, and therefore, by extension, hostile towards Mr. Depp. And again, a fairly wild strategy, but strategy nonetheless, in my view, certainly based on the arguments raised in this document here. And finally, the last one I will leave you with in this video, I'm going to obviously break these up into bite-sized chunks so that you've all got time to sit and watch each of these videos so they don't go on for far too long. But this final one here, I found, again, quite quite a far-reaching, far-fetched argument, which again in this document you can see here the arguments against this this suggestion. You'll see how far-fetched this sounds. So this was an argument about introducing. This is the response to the argument by Amber Heard's lawyers to introduce depositions of Tracy Jacobs from some time before. So this motion in limine was for an order to prevent defendant and counterclaim plaintiff Amber Heard from introducing testimony from the depositions of Tracy Jacobs that were taken in other unrelated litigations. So there was different litigation, not related to this, in a different jurisdiction between different parties years ago. Now just think about that for a moment. So this was depositions of somebody that they wanted to introduce that were in different and unrelated litigation in a different jurisdiction between different parties and years ago. Now, apart from the years ago bit, that sounds quite familiar. But certainly in this, the years ago also brings in the element that this could not possibly have any relevance. The Virginia Supreme Court Code clearly bars the use of such depositions as the prior cases in which the depositions were taken did not involve the same subject matter as the present litigation. In other words, it's a completely different subject altogether, and did not involve the same parties as the present litigation. In other words, it wasn't even the same people involved. Mr. Depp states as follows. On January 18, 2021, Ms. Heard deposed Mr. Depp's former talent agent, Tracy Jacobs. This is who they wanted to introduce previous depositions from. Ms. Heard has submitted extensive designations from Ms. Jacobs' depositions for use at trial. If she wished to further depose Ms. Jacobs, she could have done so. She, in fact, would have done so. Ms. Jacobs was deposed pursuant to a third-party subpoena in California, which presumptively limits a deposition to 7 hours, but allows for further time beyond that where appropriate. Moreover, Ms. Jacobs or hearing or was out of the Commonwealth or taken in previous action involving the same subject matter at the present litigation. And so for all these reasons, the two prior depositions that were taken in connection with separate actions and separate parties should be excluded. So just, bringing your head around that just for a moment, trying to bring in depositions, witness evidence, if you like, from parties not party to the present litigation, separate issues to the present litigation from years ago, clearly I don't think you need to be a lawyer to know that that is not relevant and should not be just dragged in for the purposes of bolstering a case here. So these were just but a few items that I found of interest. Trying to drag in the UK court decision to essentially, which would essentially sway the jury, trying to tarnish the police officers and to say that they didn't follow procedures, and then blaming Adam Waldman, then blaming alleged conduct by JD against other people and alleged arrests and so on, then blaming social media, and then the links with the Russians and alleging that there's a link with Russians to social media activity that was not proven, and then trying to drag in other evidence from someone from years ago from a completely different litigation. There's a lot more to go through in here, but as I said, I'll limit these videos to bite-sized chunks. I hope you do enjoy them. Please do hit the like button and subscribe and hit the bell if you haven't done so. And just a note to those that this will sound odd, to those that watch these videos but then say that I shouldn't be talking about these topics anymore because it's over weeks ago and so on, even though they watch the videos. For you that do watch them, clearly there are lots of legal issues here that come out of this trial. It is not just about the two people. It's not just a pop discussion about stars having arguments and legal battles and so on. Of course, there is that, but there is also lots of underlying legal issues that it gives us the opportunity to explain these to you, as we've had our Mr. Robertshaw on many times discussing these legal issues with you, and it gives us this opportunity to really discuss these legal arguments, the rules of evidence, the jurisdiction, how evidence is brought in, how it's excluded, how it's fair, unfair, admissible, inadmissible, so on and so forth, and legal tactics. And so to that end, if anyone watching has a legal issue, a legal battle, if you will, that's either ideally not yet started, not yet live, but is certainly in argument, we would like to, as we did with our Ashley Neal discussion, which I'll link that in the description below so you can get a feel for what I'm talking about, where we really talked about the issue in depth. I say we, Mr. Robertshaw and I, discussed that issue in depth, gave you our views on it. Can't be taken as legal advice, of course, because it's not the same. It's not a replacement for legal advice, but we can sit and talk about all of these issues and these arguments, and we can even go insofar, if both parties to the dispute were to agree, to confirm it as an arbitration, and we can do it live. We can do it here and discuss the evidence for and against, and if both sides sign an agreement, then that can be a binding agreement if it's done under arbitration law. That would obviously be free to the parties involved with their full consent and disclaimer and so on, particularly if they've signed agreements to be bound by the decision as an arbitration. And as an interesting idea, we can even throw it out to you, the viewers, if we did this on a live broadcast, to put it to a vote where we can explore the evidence live, and then you can vote as to which party is in the right and which party is in the wrong. If you find that interesting, I think that's a fairly unique idea. If you find that interesting, we are up for doing that. Let us know by email or in the comments, or join as a member so that your comments jump out, somehow get our attention. Get our attention for that. I would be very interested in doing that. I know Mr. Robertshaw would as well. In the meantime, please do make sure you smash the like button and hit the subscribe button and the bell, and leave a comment and all those kind of things, because YouTube doesn't always surface these videos to you unless you do all of those kind of things, because YouTube likes the interaction. But in the meantime, I really thank you for your attention, your kind support, subscribing to this channel, and to the Black Belt Floof, who is down on the floor over here. She's over here just having a nice little sleep down there. So in the meantime, thank you so much for your attention. Thank you for watching, and I will see you next time.